Rescission is an equitable remedy which allows an innocent party to cancel the contract by rescinding it or if there has been misrepresentation by the other party, raising that misrepresentation as a defense if sued for damage or specific performance by the other party. Its purpose is to reverse the contract and restore the parties to as near as practicable to their original pre-contractual positions, relieving each party of their obligation and permitting recovery of any benefit conferred on each others.
If a party breaches his promise under a contract, the party not breach the right to rescind, terminate a contract, refer Section 40. Effect of refusal party or to perform wholly promise. When a party to a contract has refused to perform or disable himself from performing his promise in entirety, the promise may put end to the contract unless he has resigned by word or conduct. His acquiescence in is continuous.
If the party not in defaulted, party be restored or return refer on Section 65 and illustration to Section 66 of Contract Act 1950. Based on Section 65 of Contract Act, it is consequences of rescission of voidable contract. When a person of whose option a contract is voidable rescind it, the other party thereto need not perform any promise therein contained in which he is promiser. The party rescinding a voidable contract shall, if he has received any benefit thereunder from another party to such contract, restore the benefit so far as may be to the person from whom it was received. Then, illustration of Section 66, T pay Harish 1,000 ringgit in consideration of Harish promising to marry Eva, T daughter. Eva is dead at the time of the promise. The agreement is void, but Harish must repay T 1,000 ringgit.
Court on 26 January 2011, which was granted to appeal against the decision of the Court of Appeal given 29 October 2009. 6 questions were proposed for our consideration. We hear the appeal on 14th in June 2011. We received our decision to consider the points raised by the parties. We now give our judgment. For consistency in this judgment, the appeal is referred to as the plaintiff and the respondent collectively as the defendants. When necessary, the defendants will respectively be referred to as either the first defendants or the second defendants. In coming to its decision, the Court of Appeal by majority upheld the judgment of the High Court given to 22 June 2009 dismisses the action of the plaintiff. For the reason given below, we dismiss this appeal because we uphold the decision of the learned High Court judge as affirmed by the majority in the Court of Appeal that the defendants want justified in termination of the contracting.
The courts below have truly dealt with the fact in this case, hence we need only to highlight the relevant and pertinent fact for the purpose of this appeal. An agreement termed as a Property Development Agreement, which is PDA, was entered into the parties concerning 15.5 acres of land, which is the development property located in Damansara Heights. It is not in doubt that the development property belongs to the first defendant. Under the said PDA, the plaintiff was given development right over the development property for 15 years. Commencing for 4 July 1994, it is common ground that the plaintiff does not have any interest in the land, be it legal or equitable. All the plaintiff had over the property was development right. Upon the execution of the PDA, the plaintiff did not make any effort to commence development on the development property. It is not in doubt that the plaintiff failed to take any proactive measure to develop the said land. In consequence, by letter date 45 October 2007, the defendant issued his termination notice to the plaintiff, citing the letter's failure to develop the development property as a material breach under the PDA and a repudiation of the same. As such, it was declared that the PDA would effectively terminate on 25 November 2007. It is not in doubt that the termination notice was issued some 13 and a half years into the subsistence of the PDA.
The case of the dispute between the parties is this: whether the plaintiff was required to continuously develop the development property over the span of 15 years or whether the plaintiff was at liberty to commence development as and when it felt the time was right, so long as it had commenced work within the 15 years period. It is to be noted that only upon service of the termination notice did the plaintiff take some steps towards initiating the development works. However, this effort did not eventually materialize. The plaintiff commenced an action against the defendants for wrongful repudiation. The High Court dismissed the action. The Learned High Court judge, having carefully scrutinized the PDA, found inter alia that as the PDA was a commercial contract, it ought to be construed in a commercially sensible manner, which the parties all along intended for time to be of the essence. As such, in his view, it was reasonable to assume that the parties intended to have the whole development property land developed within the time period of 15 years. The Learned High Court judge did not think that the PDA intended to give the plaintiff the liberty to commence development at the tail end of the 15-year period. The Learned High Court judge also made a finding of fact that efforts to develop the development property were only made upon the issuance of the termination notice by the defendants and nothing of the sort was done 13 years prior to that. Hence, the Learned High Court judge took the view that the plaintiff could not insist on holding on to remaining 19 months of its development rights simply because the delay of the plaintiff's part was so prolonged to it justified the defendants to terminate the PDA.
In upholding the judgment of the Learned High Court judge, the majority in the Court of Appeal was of the view that the Learned High Court judge was right in arriving at his conclusion. The majority agreed that the PDA, being a commercial contract, must be construed in a commercially sensible manner. The majority also opined that the PDA did not merely impose an obligation for the plaintiff to commence development by applying and obtaining a development order, but to actually undertake and complete the development on the development property within the said 15-year period. Thus, as time was of the action of the PDA, the plaintiff was not at liberty to commence development at its own leisure. Thus, the majority in the Court of Appeal concluded from a legal standpoint that the defendants were entitled at law to terminate the PDA and need not have waited for the expiration of the 15-year period. The plaintiff clearly by its conduct was in breach of the PDA. The majority also rejected the plaintiff's contention that it would be entitled to a 3-year extension if the development order had been granted by the authorities. The majority found that there was no automatic extension under the PDA, that to adopt such an interpretation would not be commercially sensible, that such an interpretation would be contrary to the implied term that time was of the essence of the contract, and it was not possible for a project of such a magnitude to be completed within a 3-year period. The minority view in the Court of Appeal held that time was not of the essence under the PDA because the plaintiff had been given 15 years to develop the development property. There was no time set for the plaintiff to perform its obligation, and there was no requirement for the plaintiff to commence development within a reasonable time. In coming to such a view, the minority took the view that such a termination could only be justified under the doctrine of anticipatory breach. However, no such circumstances existed in the present case because the plaintiff had not indicated by its words or conduct that it would not be able to perform its obligation at the expiration of the said period. The minority was also of the view that the plaintiff was entitled to develop only part of the land and was not obligated to develop the whole land. Accordingly, the minority concluded that since the time period was still in existence, the defendant's termination was premature and unjustified.